The European Union's AI Act stands as a landmark piece of technology legislation. But any law, no matter how ambitious, is only as strong as its enforcement. So today, we're going to examine the very heart of that enforcement mechanism, focusing on the critical part played by Article 70.
And that brings us to the central challenge, doesn't it? It's one thing to write a comprehensive law for artificial intelligence, but it's an entirely different matter to ensure it's actually followed. Who, exactly, is going to hold AI developers accountable across 27 different member states, each with its own legal framework and culture? This is the fundamental puzzle the AI Act had to solve. Here's our roadmap for understanding how they did it. First, we'll identify the key enforcers. Then, we'll unpack the rather elegant gateway versus guardian model they employ. After that, we'll explore the support system that empowers these authorities and examine how the entire framework is designed to learn and adapt. And finally, we'll connect these pieces to understand why this matters for all of us.
All right, first things first, let's meet the enforcers. Now, the answer to our question isn't some single all-powerful EU AI police force. Instead, the Act wisely builds its foundation on a network of specialized national bodies operating within each member state. They're called National Competent Authorities, or NCAs. You can think of them as the dedicated teams on the ground in every country, responsible for the day-to-day work of making the AI Act a reality. While this model isn't new, its specific application to a technology as complex as AI is what makes it so important here. What's really interesting is that this structure evolved. The first draft back in 2021 envisioned just a single supervisory authority for each country. But through the legislative process, it became clear that the job was really two distinct roles. So the final act split the responsibilities, creating a much more specialized dual authority system that provides a very clear division of labor. And this evolution leads us to what can best be described as the gateway versus guardian model. This concept is really the core of the Act's enforcement strategy, and it's a powerful solution to a very complex problem. This table really breaks it down beautifully. On one side, you have the gateway. Its official title is the notifying authority, and its role is entirely pre-market. It acts as the gatekeeper, assessing high-risk AI systems before they're allowed to enter the EU market. It's their job to scrutinize the technical documentation and the quality systems. On the other side, you have the guardian, the market surveillance authority. Its role is post-market. It is the watchdog, constantly monitoring AI systems that are already in use, investigating any incidents, and safeguarding citizens' rights. Put simply, one opens the gate, the other patrols the market. And let's be clear, this guardian has significant authority. These aren't passive regulators waiting for a phone call. They can proactively scan the market using a central EU database. They're mandated to investigate serious incidents, and they must cooperate with other rights-focused agencies. But here's the real power. They can demand access to an AI's training data. And, in exceptional cases, they can even request access to the system's source code. That is a profound level of oversight. Of course, having powerful authorities on paper is one thing. Making sure they can actually do their jobs effectively is another challenge entirely. So now let's look at the support system the AI Act constructs around them. Article 70 is very direct on this point. It states that member states must provide their authorities with what they need to succeed. This isn't a mere suggestion. It's a legal obligation covering three essential pillars: adequate financial resources, the necessary technical equipment, and, crucially, well-qualified human resources. And when the Act says well-qualified, it's not being vague. This isn't a job for general administrators. The teams within these authorities must have deep, multidisciplinary expertise in AI itself, in data protection, cybersecurity, fundamental rights, and even potential health and safety risks. This is a highly specialized technical mission. To give this authority a tangible sense of weight, consider the penalties. For the most serious violations of the Act, these bodies can levy fines of up to 30 million euros, or 6% of a company's total worldwide annual turnover, whichever is higher. Now that is a figure that gets attention in any boardroom on the planet. But with great power comes great responsibility. To build a system worthy of trust, the regulators themselves are also regulated. Article 70 requires the authorities to guarantee their own cybersecurity, while Article 78 binds them to strict confidentiality when handling sensitive information like trade secrets. This ensures the entire system operates with integrity. So we have the enforcers, and we have the resources. But AI technology evolves at a breathtaking pace. A static rulebook would be outdated almost immediately. That's why the AIX framework isn't static. It's designed as a living system that learns and adapts through a continuous governance cycle. Let's walk through this feedback loop. It begins at the national level, where each authority conducts an annual self-assessment. Then, every 2 years, their governments compile these findings into a report for the European Commission. The Commission then passes these reports to the European AI Board, which analyzes them all to identify EU-wide trends and challenges. From this analysis, the board issues harmonized guidance and best practices. And finally, that intelligence flows back down to inform and strengthen the national authorities, starting the cycle all over again. Now, this is arguably the most forward-thinking part of the whole structure. It's more than just administrative reporting. This process creates a learning system. You could almost call it a regulatory brain for the entire EU. It transforms scattered data points from 27 different countries into systemic intelligence, allowing the entire network to adapt, to share what works, and get smarter over time. So let's step back and bring it all together. Why does this intricate structure of authorities, reports, and feedback loops actually matter in the real world? It matters because this is the very foundation upon which a trustworthy AI ecosystem can be built. First and foremost, it builds public trust. When people know that there's a clear, accountable, and independent guardian with real power to investigate and penalize wrongdoing, they're far more likely to have confidence in the technology. And without that foundational trust, the widespread, beneficial adoption of AI simply cannot happen. Second, and perhaps counterintuitively, it actually enables responsible innovation. A clear and predictable regulatory environment doesn't just stifle creativity, it can foster it. It gives innovators the rules of the road, allowing them to build with confidence and legal certainty, knowing they're operating on solid ground. And finally, and most critically, it protects the fundamental rights of every citizen. The entire system, from the gatekeeper at the entrance to the guardian watching systems in the wild, is ultimately designed for one primary purpose: to safeguard our rights and our safety from the potential harms of this powerful technology. The AI Act's enforcement engine is, without a doubt, a complex and ambitious undertaking. It is one of the most comprehensive attempts anywhere in the world to govern this transformative technology. And as other nations grapple with these same monumental challenges, the EU has laid down a detailed adaptive blueprint. This leaves us with one final, critical question. Is this the model the rest of the world will follow?